Further hearing in Eli Lilly and Company against Actavis UK Limited and others.
Mr. Alexander.
Can I just start by giving your lordships some references that you were asking for in response to questions in particular from my Lord Mance in relation to examples where the test applied here and in other countries which employ it don't preclude the finding of equivalence in appropriate cases. There is actually quite a useful summary of that in Terrell, which you find at Authorities Bundle 4, tab 1.
Thank you.
Which is MS 4258.
Yes.
Paragraph 9.81.
Yes, I see.
Which might be described as purposive construction and English equivalence in practice in a range of cases, Taylor, Nishida, Plastus, SEB, and Niken. There are, of course, other cases. For example, in the pharmaceutical field.
These are all UK cases.
These are UK cases. The position is actually similar in other countries, and we can dig out those references as well, if your lordships would like. I was just focusing on the UK, and the reason for doing so is because, in a way, the UK might be regarded as the paradigm jurisdiction, and if it works here, then one might say, well, there's no reason why it should not work elsewhere. And also, obviously, one's got a full record that the cases that your lordships can consult. In the pharmaceutical field, Ranbaxy, my lords, I mentioned the Ranbaxy case yesterday, the Irish decision, which then cross-refers to the UK decision, which was a decision that my Lord Neuberger may remember, because you're a member of the panel there. That was a case where there was, in a sense, a claim which prima facie related only to the racemate of atorvastatin, because the formula in Claim 1 was not identified as being one of the optical isomers. And for those less familiar with stereochemistry, perhaps I can just very briefly explain the point there. That there are some pharmaceutically acceptable molecules which come, where they have the same chemical formula, but because the different relevant elements are arranged in different ways around a central atom, you can have handedness of molecules, where you have the same basic composition, but a different, what's called stereochemistry. And it's quite common in pharmaceuticals that only one, the left or the right hand, will be the pharmaceutically acceptable one, and there may even be toxicity issues as a result of including the other one. This was a case where prima facie the claim was to production of the racemate. That is, and a racemate is a 50-50 mixture of both hands. And the court there said, well, you, in that case of a generic company, are only taking one hand, the hand that works, effectively, as the pharmaceutical product, and we don't regard that as excluded from the claim. And what we will do, rather than spending time on this now, subject to my lords, is provide references to those and supply copies through the court, if that is a convenient way of proceeding. There is another example, of course, Pharmacia and Merck, again in the Court of Appeal, which again directly refers to the improver questions. And so if the proposition is thought to be the case, that in jurisdictions of which this may be a prime one, which do give serious meaning to specific wording used in a claim, and that thereby precludes a finding of infringement in appropriate cases, that would not be a justifiable assumption. Can I then briefly explain why there may not be a very large number of such cases? And in fact, the reason for that comes from the structure of the law itself, which I outlined earlier. for some patents, there simply is no scope for equivalence precisely because they are specific. And that is not a bad thing, it is a good thing.
Specific in what sense? Linguistically or functionally?
Having regard to the purpose of the specific element claimed, they are specific with respect to that element.
I mean, do you mean that there are some patents where every element of the description is essential to the way it works?
There are some patents where that's certainly the case, and there's some patents...
Or are you going further and say there are some patents which are linguistically specific, although there are elements which are immaterial?
Yes, both are true.
Well, the latter may be a lot more questionable, because if there's an element that is immaterial to the way that it works, then you've got to have something, surely, other than the mere use of a description which includes an immaterial element to demonstrate that the draftsman intended it to be treated as essential, in spite of its lack of materiality.
Well, one might say is that...
This is question 3.
It is. One might say that, exactly, that is question 3. And one might say that the thing that demonstrated the draftsman's specificity was the particular choice of language that was used to describe the element in question.
In that case, all one is doing is applying the language and not applying a doctrine of equivalence at all.
Well, no, what one is doing is one is saying of the language that has been used, this language is specific. And it is not to apply a doctrine of equivalence. It is to say that there are some patents for which, for given elements, for reasons that are technical reasons or legal reasons, there is no room for equivalence of that element because of the language used.
The question is, what sort of language will be enough to demonstrate that that's the intention? The whole point about equivalence is that it proceeds, see question 1, on the footing that there may be some things in the language which are not essential technically and are not intended to be essential legally. Now, merely putting the language in isn't going to answer the question whether it's intended to be essential legally. One has got to find something there which demonstrates that the draftsman wished even technically immaterial aspects of the language to be treated as essential, and merely having the language can't possibly be enough to produce that result.
My Lord, that's right, which is perhaps why in these cases it is so important for there to be orientation in terms of reading the specification from the perspective of the person skilled in the relevant field. Because if the person skilled in the relevant field says, well, looking at this patent, I can see that there are good reasons for having adopted specificity in the choice of that term, then to attribute specificity to that term accords with the manner in which those to whom the document is addressed would understand the document.
So he would say to himself, for example, they were obviously worried about this or that possible attack on validity.
It may be that there are two things.
I mean, is this a speculative process? They might have been worried. Or is it an actual, is it a specific reason why those particular words, if not treated as linguistically essential, would give rise to concerns?
My Lord, there may be 3 separate kinds of reason why a term may be thought to be specific. The first kind of reason might be what might be called purely technical reasons, nothing whatever to do with the grant process or validity or
the way it works.
Anything like that, because there is a technical reason to think that the particular choice matters overall.
Well, then you wouldn't get past question 1.
Leaving entirely aside the question of well, no, because question 1 is answered on the assumption that you've worked out eventually that it doesn't matter. But the question is whether you would have thought that it did. So that's a technical aspect. The second aspect might be said to be an assumption, because the person reading the document doesn't know what is in the mind of the patentee. There's no window into the soul, as Lord Hoffman said, what the patentee had in mind. But nonetheless, because there are possible reasons why a patent might be invalid or might not have been granted, specificity is to be assumed. And third, to answer my Lord's question, there are cases where it may not be possible to tell exactly what the reasons are for the particular choice of specificity. And in that case, the question really, or the policy question, is whether that should be the patentee's problem, if I may put it like that, or everyone else's problem to work out what the reasons might be. And the tendency of the law, and your lordships have seen that reflected in Amgen and indeed other cases, is to say precisely because one of the reasons is that because a patent is a document written in terms of the patentee's own choosing, the public, other people, ought not to have to speculate as to the reasons for the specificity chosen.
Contra proferentum.
There is an element of contra proferentum. I would perhaps put it slightly differently. Because of the statutory scheme for the grant and examination of patents, which requires a claim to be clear and concise.
Right.
That is a requirement under the EPC Article 84. It is a requirement under the statute Section 14. The claims are required to define the invention. In those circumstances, one ought not to expect a loose use. And that is an issue that was actually picked up by Lord Hoffman in Amgen, just coming back to the point of examples, where he said that a patent specification is not a document inter rusticos, and it's not inter rusticos for all kinds of reasons, and that ordinarily these are drafted with professional help. But importantly, that he said one wouldn't expect it to be very frequently the case that the terms that had been used, which were intended to be and supposed to be precise terms, had in fact been used in a way that was imprecise.
Yes, I see.
So that's in a sense the context in which one comes at the number of cases where patents are treated to mean what they say, and the number where they aren't.
Yep.
So that's the only point I would want to make on that in response to my Lord Sumption. The other point in response to my Lord Neuberger on examination procedure and interchanges, we looked up overnight because you asked what is the average number of interchanges, and on the EPO website there is a short printout which I'll just hand up, which in essence says that the aim is to get the matters resolved within 2.
Thank you very much. That's very helpful.
We also have the full rules, but I don't think those are needed for present purposes.
Thank you.
Finally, just on references, I mentioned my Lord Schneidmesser yesterday, and just for my Lord's notes, that is in the Authorities Volume 5, tab 8, and the relevant passages of German law which indicate that it was, to some extent, following the general approach of Katnick, paragraphs 36 to 40 at MS 424525. And of course, your lordships have read the Oberlandesgericht in this case, and their analysis of the importance of legal certainty, which you find in the appendix, part 2, at tab 6, and I would commend the passages on that at MS 916 to 917.
Thank you very much.
So those are the references on that point. Can I then turn briefly to indirect, and I hope I can take this pretty briskly.
Thank you.
Essentially, the points are all encompassed in the judgment of the Court of Appeal,
Yes.
paragraphs.
This is a fairly academic issue in light of the subsequent decision.
It is, and that's what I was going to say
Justice-
first of all.
Of Mr. Justice.
It's become academic, so I don't
Which is why everyone's giving it such short shrift. I understand.
I don't want to spend a lot of time on it, and
perfectly
perhaps I can just
sensible.
highlight the core points.
It's exactly the right thing to do.
In my respectful submission, I can't really put it better than it's already been put in the case. So at this point you probably say, well, if that's the case, I should just sit down and not trouble you any further. But there are just 2 or 3 points.
Yes, indeed.
First of all, we say that the judge got it right and his approach was realistic. This is a patent about pemetrexate disodium, at least on our primary case. And to say that you're putting an invention into effect if what you're doing is a dilution which doesn't use pemetrexate disodium is itself artificial and involves essentially adopting a claim construction that is of one kind under one head and a different kind under the other head. And we've set all of that out in our case in some detail.
Thank you very much.
On the question of solid liquid form, that's actually not the core point here, although it is a point. And the judge didn't proceed on the basis that that was the touchstone of liability or non-liability, and it isn't. Although our primary position is that the salt should be regarded as a salt. Effectively, his point was, no, it isn't. His point is whatever it is, it's not being used as a method of in the manufacture of a medicament by anyone. There are a few additional points. The prosecution history, of course, we say precludes this argument. Effectively, in the prosecution history, as your lordships will have seen, what happened was that Lilly had effectively said, we want to have the diacid as our claim, because the examiner had said, well, what you mean by pemetrexate is the diacid. So and they said, we can't have that. So Lilly said, okay, we're not going to have the diacid, we're going to have pemetrexate disodium instead.
Diacid means basically the anion.
The diacid is exactly, and the last 2 interchanges are important there, because
right.
the examiner says, and I don't need to turn it up now, by pemetrexate, you mean diacid, and that is a specific chemical, which has a particular chemical.
Well, once you're into liquid form, you're into the diacid, not into the disodium, because the 2 ions have
Indeed. And the examiner said you can't have that, and we respectfully draw attention to the anomalous results that would flow from that aspect. And that the claim requirements would not be met in any event. It's said by Lilly, well, this is to mischaracterize the Swiss form claim. We respectfully submit, and it's a point that I made yesterday, you can't simply write out of the Swiss form claim the requirements, that there is a use for the manufacture of a medicament in this way, because effectively what you're then saying is, well, we're going to treat a Swiss form claim as though it was an EPC 2000 claim. Well, it's right to say that's right in some contexts to do that, but in other contexts it simply isn't right to do that. The fourth reason it actually reveals a degree of confusion in the case as to how our dilution works. We don't have a 2-stage make-up process because our product is different. It is a liquid formulation, so it's not made up first of all and then.
It's not a solid being dissolved.
No, it's not
a liquid.
Exactly, it's a liquid formulation to begin with, and Lilly's case seems to focus on the way in which their product is made up, rather than the way in which our product is made up. And we say that that's not the right way of looking at it. And there is, in our respectful submission, a quite artificial way of looking at this situation, which might be called the continuous dilution point, where it's said that the reason that we infringe under this head is because even though no pemetrexate disodium is introduced into the saline, there comes a point for some patients, because different patients have different amounts of saline and the salt content is different, that you get to a point where at some point there is a 2-to-1 ratio, and therefore you have pemetrexed, specifically disodium. And after that, that is being used to make a medicament. Well, that is not an approach that we submit has ever been taken to the law of indirect infringement, partly because, coming back to where I started, the law of indirect infringement is not supposed to provide a broader monopoly. What essentially the law of indirect infringement is supposed to do is to say, well, look, if you've got a third party who otherwise would not infringe, and they are nonetheless supplying into the infringing process, you make them liable as well. It's not quite joint tortfeasorship because the conditions are somewhat different. But what you can't do is broaden matters out from the primary infringement into the secondary infringement.
Ultimately, these are arguments which all amount to saying this is, as it were, a misapplication of Section 60 subsection.
It is. It is. That's the central point. And that really, subject to being told I'm missing something central out, is all that we really need to say in relation to that.
Thank you very much indeed, Mr. Alexander. Good. Thank you very much. Mr. Mitchison.
First on secondary infringement and get that done, or would you like me to give my main reply first? I'm entirely in your Lordship's hands.
Secondary infringement being just what we've just heard about.
Yes.
Probably better to hear that now, given that we've just got it in our minds.
Indeed.
That's convenient. Thank you.
My Lord, it falls to me to address secondary infringement.
Yes, indeed.
My Lord, I'll take it a little bit longer, if I may, than my learned friend, for a number of reasons. My learned friend, Mr. Alexander, acceded to my Lord's comment that it was academic. It isn't quite so. And in fact, can I just refer, I can quote from what they say in their case.
Yep.
They say in paragraph 14 that the appeal on indirect infringement is still of practical and legal importance, not only because of the commercial significance to them, but also because diluting in dextrose is, and I quote, an extra burden for the National Health Service systems who use the products. Lord, we submit that that is the wrong outcome for reasons I'll explain. But let me take it and address the points that are set out in the case which my learned friend incorporates by reference in his submissions. Lord, just for reference, in our case, the secondary infringement matter is addressed in paragraphs 306 to 317.
Yes.
And it's in our written reply from paragraphs 81 to 115.
And for fuller treatment, though. Rather fuller treatment.
Well, it was in reply. We just basically prefaced it initially and then dealt with it more fully. For convenience, my Lord, the nub of the judgment on secondary infringement is found in para 200 of Mr. Justice Arnold's judgment, and I won't go to that, it's MS 514. And the nub of the Court of Appeals finding is at paragraph 89 at page 431, and I will briefly look at that and just explain why it's right. My Lord, just as a prefatory observation, from my submissions on secondary infringement, it should become clearer not only why the Court of Appeal was correct to reach the decision they did on secondary infringement, but also why the lower court's decision on primary infringement was in error. And this arises from the underlying thrust of Actavis's argument, which is that if there's no primary infringement, there can be no secondary or contributory infringement either. That comes out most clearly from their cases, but my lords have heard an echo of it, where my learned friend says you can't have a broader monopoly in the context of secondary infringement. Lord, the proposition is wrong as a matter of logic, but even if it were the case, and let's accept for this argument that the two types of infringement stood or fell together, the case for primary infringement is all the stronger. One of the headings under which Actavis allege that the Court of Appeal was wrong on secondary infringement is under the heading irrational and arbitrary results. That's their third heading, which is addressed at paragraphs 108 to 110. Yep. For example, they say that it's strange that infringement should turn on the nature of the diluent used, namely saline, which if dextrose is used as a diluent, the pemetrexed will not infringe. And we accept, my lords, that the argument of secondary infringement may seem somewhat technical, the ongoing dilution argument that I'll mention in just a moment. It's also tangential, my lords, that the source of the sodium ions, whether they come from the bag of saline or the pemetrexed initially as solid salt or liquid concentrate, has simply nothing to do with the real invention disclosed and putting that invention into effect in patients, as the patent describes and as my learned friend Mr. Mitchison took my lords through. So to that extent, my lord, we agree with Actavis that it's odd that infringement, whether primary or secondary, should turn on such a peripheral question. Nevertheless, although the issue is somewhat technical and peripheral, that doesn't undermine the question of whether the Court of Appeal set out and applied the law correctly on secondary infringement.
We have to assume at this point, contrary to your case, that the Court of Appeal and Miss Justice Arnold were right on primary infringement.
Indeed. And you have to have manufacture of medicament using pemetrexed disodium.
Yes, but we have to also, therefore, bear in mind that your point about it being odd about sodium being so important helps you on primary infringement, but isn't so helpful to you if you're wrong on primary infringement.
Indeed. I use it as a support.
No, I quite understand. I'm not
for that reason.
Yep.
Because, my lord, activists seek to avoid infringement by eliminating sources of the sodium cation. But they do so in a way that has nothing to do with the real invention disclosed in the patent in the way of saving patients with vitamin co-administration of B12. But what it does, Lord, is it does actually inhibit the clinical options open to the oncologists, at least some of whom would prefer to use saline, which is the more commonly used diluent. And that's the reason why, my learned friend says in his case, it's an extra burden for the National Health Service systems who use the products. And we say the correct answer is that a trivial and immaterial change to the cation in this way should result in direct infringement, for the reason my Lord Neuberger observed. So the analysis on secondary infringement becomes moot. Now, my Lord, with those prefatory submissions, can I just turn to the specific arguments? Now, observation at the outset is that the terms secondary infringement and contributory infringement are often used interchangeably. And although they're legally synonymous in the context of infringement, the term contributory actually conveys more insight into the nature of the infringement. Specifically, it arises where the defendant contributes to the infringing acts by providing means essential for that infringement to arise at some later time. Lord, in this case, the decision of the Court of Appeal on direct infringement turned first on whether, as Actavis had contended, the claim was limited to the solid form of pemetrexed disodium, or alternatively included a solution of pemetrexed disodium. Now, my learned friend can't evade the point quite as easily as he seeks to do by saying it's not a big point, but it's still a point. And one has to understand really why it is a point. And the reason for that is, my Lord, is that the Court of Appeal in paragraph 87 of Lord Justice of the Court of Appeal's judgment explained how it is that the argument of Actavis proceeded on the basis that the claim was limited to the solid form of the disodium salt. And that submission, my Lord, is maintained in this court. It's a point, as my own friend says, but it's clear from paragraph 220 of their case, and I quote to save time. He says, by contrast, Actavis's approach that the starting material must be solid, pemetrexed disodium, and nothing else, gives rise to a clear and simple limit to the monopoly supported in the specification, which Eli Lilly asked the EPO for. Now, ignoring those last words, because that raises the prosecution file, the reference to solid is in parenthesis in quote from 220 of their case, because the word solid is nowhere to be found in their claim. And it's fair rhetorically to ask, why is it necessary for Actavis to maintain this as a point and limit the claim yet further to the solid and not the solution form? The answer we submit is clear, because if a concentrated solution of pemetrexed disodium were used to make up the infusion bag with saline, with yet further ions coming from the saline solution, an argument of non-infringement, we submit, would be untenable. It's disodium becoming yet more disodium. And certainly on a contributory infringement, you would never escape contributory infringement by saying it was liquid rather than solid. And likewise, the point that my learned friend, one of the points my learned friend makes this morning is we don't have a two-stage process because we're not a solid, we're a liquid to begin with. Now, my Lord, it's very important procedurally to see how this matter proceeded, First of all, as one sees from the case, right at the beginning, all forms of pemetrexed, dipotassium, and various others are mentioned, because they want these as backups. The scope of the declaration sought is not limited to the diacid. It never has been. The scope of the pleading is never limited to the diacid. It never has been. And furthermore, it was always clear before the court below, and I quote from a document that they served, the reference is Appendix Vol 2, tab 39, hard copy page MS 1209. Actavis' claim for non-infringement relates to pemetrexed ditetromethane generally, that's the diacid form, and is not confined to one specific formulation thereof. They've always wanted these proceedings to cover the gamut of their potential products. And in those circumstances, my Lord, it's wrong at this stage to pass it. In the end, the point actually goes nowhere, because frankly, once you have a procedure of dilution, as the judge described, and a procedure of further dilution, then in those circumstances, we say there is contributory infringement. And Lord, my learned friend describes it in a fairly pejorative form, because the answer we submit is clear. If you take a concentrated solution and you use that to make it up in the infusion bag, you have a process of preparation, a process of manufacture. And as the pharmacist goes through the dilution process, once there are sodium ions present in the solution, there is use of pemetrexed disodium in the manufacture of the medicament, as is the case for all patients. I don't know where my learned friend gets this proposition that it's only for some patients. There were figures before the courts below that, and as my lords may be aware, the dose that you give to the patient is calculated on the body surface area. And therefore, there is a calculation based on weight that the physician can do to work out what your square meterage happens to be. And the figures were for a slim female, it was 2.1 ratio of salt to pemetrexed, sodium to pemetrexed. So that was for a large male. It's 4.3 saline to 1 sodium to pemetrexed for a slim female. And there was no patient identified for whom there was anything less than 2 sodium molecules to 1 pemetrexed, at least, in the bag at the time it was administered to the patient. Now, my lords, with that, can I just look at the nub of the Court of Appeal's findings? It's paragraph 88 to 91.
Right.
At 13C.
Yep.
Its reasoning, which we say is unassailable.
MS 431.
MS 431.
Or 434 on the electronic, yep.
And at no time in this process were we seeking to duck the fact that the claim says use in the manufacture. And if I could ask the court to pick up the last 4 lines of paragraph 88. Lord Justice Floyd says in the last 4 lines, Lilly's argument does not involve saying that the claim does not require pemetrexed disodium. It asserts that it does require it, and the pemetrexed disodium is used in the process for making up the medicament. And then if I could pick it up just 5 lines down in 89. The language of section 60 sub 2 does not require the supply of an element of the claim, but a means relating in italics, to an essential element. A means for releasing pemetrexed ions into solution relates to an essential element of the invention, where the invention calls for pemetrexed ions and sodium ions in solution, particularly as it's the presence of the pemetrexed ions in the manufacture which is essential for its efficacy as a medicament. And the importance of those words will become apparent, or be apparent. The invention is then put into effect when the pharmacist makes up a solution using pemetrexed dipotassium, because there comes a stage in the course of that activity when pemetrexed disodium is present and is used. He then refers to Grimmy, and I don't detect any criticism in the case of the application of Grimmy. And he says in 91, applying this reading, pemetrexed is a means relating to an essential element of the invention, notwithstanding that potassium is dissociated and sodium is caused to be present in order to put the invention into effect. So you will have pemetrexed disodium in the bag. You will be using it in the broad sense that use is an incredibly broad term in patent law, and you are manufacturing a medicament. And none of that is at odds. In fact, it's entirely consistent with the nature of the invention And the fact that is basically, it's a means relating to the essential element of the invention, because the essential element of the invention is the pemetrexed in solution, and you have a vehicle for doing that, namely the pemetrexed dipotassium, which becomes pemetrexed disodium in the course.
So the answer is that once pemetrexed disodium in solution is within the scope of the claim, if you need, and Actavis, it said, did need, in order to make its product, which would otherwise not infringe, to have as part of the process of manufacture a stage where you have sodium ions and pemetrexed ions in solution, bingo, you're caught, because you have sodium and pemetrexed ions in solution. Therefore, you have disodium pemetrexide, albeit in solution.
Yes.
That's what it is. It's as simple as that.
It is, my lord.
Yep.
And it is a necessary fact that you go through a stage of having in your hands pemetrexed disodium.
The infringing article, as it were.
Yes.
And therefore, it becomes vital for your case. I'm not saying it's a problem, but it becomes vital for your case that the claim is not limited to solid pemetrexed disodium, because they never have that. They have it in solution.
Precisely.
Yes, okay.
And that's how they had to essentially get away from it, because there's absolutely no doubt. And we haven't looked at the section on construction, which is the solid point, but it's from paragraph 74 to 79 of the Court of Appeal's judgment. And it's unassailable again, because pemetrexed disodium is what is being referred to as being the solution that is being injected into the patients. Yes. And perhaps most clearly it comes out in the second half of Lord Justice Floyd's argument, where he said this is made plain amongst other places in the specification where the patentee refers to treating patients with an intraperitoneal injection of pemetrexed disodium. This can only refer to an injection of a solution containing pemetrexed and sodium ions in dissociated form, as the solid disodium salt will necessarily have been dissociated. And the judge at first instance found it was common general knowledge that pemetrexed was subject for clinical trials in chemotherapy. It's also common general knowledge that you don't inject solids intravenously. That is extremely dangerous. You only inject a solution in a bag intravenously. So what is being referred to as pemetrexed disodium manifestly covers the solution for injection as much as it covers a solid, and therefore to actually take one step back and say we've now got to construe this claim not only as strictly limited to disodium in terms of the identity cation, but it must be in its rigid lattice form in strictly 2-to-1. Because the Court of Appeal really had to consider two issues. First, whether the presence of sodium ions in excess of 2-to-1 should be regarded as material. And second, whether the presence of other counterions other than sodium could take the solution, therefore, out of the claim.
Right.
And it was common ground that the counterions in the various Actavis' products made no difference. So in paragraphs 78 and 79, it answered both questions in the negative. It said pemetrexed disodium in the sense called for by the claim would still be present, despite the presence of more sodium ions.
Can I just stop you there? Do you understand correctly? Sodium, if I remember rightly, has one positive charge. So disodium would involve two sodium positive charges. Does that mean pemetrexed was a sort of had 2 electrons extra?
That would be my understanding.
Yes.
But yes.
That's fine. Okay, thank you.
So, well, the fact that you...
2 loose electrons or additional electrons to give it to a double charge, as it were.
And, Lord, it's never been the case that because there is more than the disodium, as I say, you go through this stage of having disodium to a ratio of more than 2 sodium ions to 1 pemetrexed, and you use that to go further. And well, the fact that you go further, the long-standing quote in patent law referred to by Lord Justice Floyd was that of Lord Justice Bowen in the famous Wenham gas case, where the superaddition of ingenuity to robbery does not make the operation justifiable. Lord, we say, and you can say there's no tort of non-infringement, but likewise, that's a quote that rests on the other side of the equation. So, my Lord, there's no point of general public importance on
No, but the point is here, nonetheless.
The point is here. And, Lord, my learned friend in his submission that basically you can't have a broader infringement is wrong for this reason, because their submissions in their case always conflate, and wrongly conflate, the questions on the one hand of direct infringement by an equivalent which falls outside the literal scope of the claim. On the other hand, with the issue of indirect infringement by supplying means relating to an essential element of the invention. Now, Lord, they are different concepts and are not to be elided. The purpose of Section 60, subsection 2, is to provide infringement in circumstances which are not in themselves an infringement, but are being supplied to supply an essential element, that a means relating to an essential element. The two do not run hand in hand. It is not possible to say that there is not use in the manufacture of a medicament, because there is, as I've explained, such a manufacture in the medicament. The fact that the saline is the source of the sodium ions cannot, on any reasonable basis, matter at the end of the day. What is important is what is given to the patient. That's what's going to achieve the technical effect of reducing the toxicity of the pemetrexed. What happens upstream is by the by, and if you provide the means that mean that the saline ions, the salt ions are there, sodium ions are there, in those circumstances, everything is met. There is use of pemetrexed disodium in the manufacture of a medicament for use in combination therapy.
Yes.
Now, Lord, in a sense it does come out, if my Lord looks at paragraph 84 of the Court of Appeal's judgment, and as I say, the judgment's not here to be criticised, because what was being put before the courts below was the concession that what Actavis were going to do was identical to what Lilly did. So he took the Elimpta product and process description, the summary of product characteristics on page MS 429. And what you have is section 6.6 of the SMPC states as follows. Now, it starts with reconstitute 500 ml vials.
Sorry, which paragraph are we? I do beg your pardon.
84.
Thank
It's
you,
the
yes.
second in
Yes, I have it. Thank
sub 3. You reconstitute the 500 ml vials with 20 ml of sodium chloride, so resulting in a solution containing 25 ml of pemetrexed. You swirl it. So basically, you take the lyophilized powder, the freeze-dried powder, and you make a pre-solution, if I can call it that way. You adjust the pH.
Yep.
And then it says the appropriate volume of reconstituted pemetrexed must be further diluted to 100 ml with solution chloride without preservative
Sodium.
and administered as an intravenous infusion. And the appropriate volume is what is determined by what dose the doctor has prescribed in order to get the right concentration of solution. And by any measure, that is use in manufacture. So, Lord, we say there, the judgment of Lord Justice Floyd.
So in a sense, there are two arguments. One is, or three arguments perhaps against you. One is it doesn't apply to the liquid. Secondly, it's pure happenstance. You've got sodium ions and pemetrexid ions. And thirdly, you've anyway got the wrong proportion of sodium ions. It's more than di.
Well,
DI.
more than di makes no difference.
But then I know, but those are the arguments.
Those are the arguments. I believe I have dealt with all of those
Yeah, you have.
in turn. There is another argument that my own friend touched on, which in a sense is a matter of overlap with my own friend Mr. Mitchison,
Yes.
about the prosecution history. Now, in a sense, nothing was said about what would or would not amount to a contributory infringement. Now, my own friend Mr. Mitchison is going to respond on the fact that it doesn't even say what they say it says. To say that the claim has been limited to the preferred embodiment says nothing about exclusion, but I won't...
You come back to the point that in a sense, if you've got salt, what we call salt vernacularly, in water, that dissolves into sodium ions and chloride ions. We'd still talk about it as if they're salt in the water.
Lord Justice, you talk about salt in water, and indeed, Lord Justice Floyd made the point in his judgment that it's not strictly right to call the administered fluid in the patent as pemetrexid disodium.
In that sense, it isn't. No.
It calls it that because, well,
In the same
answer
way,
is
it's shorthand, if you like.
yes. You know, if you took a strict literal approach, as my own friends do, and say, well, potassium, pemetrexid disodium means 2 atoms of sodium to 1 of pemetrexid. None of these would infringe that were administered in the patent. They would exclude the ones in the patent. because they all exceed
Understand.
the number of sodium ions. So that really puts that point to bed in my respectful.
Can I just, sorry, just having said I understood it, what is described in the body of the patent involves disodium permethacid in sodium chloride solution. Yes. So added sodium.
Yes.
So you're above the 2-to-1 there too. Thank you.
And that's the point.
Yeah, no, that's the point that I said I'd understood, but in fact I'd overlooked. Thank you.
Now, just dealing very briefly with the points that I picked up. First was the patent prosecution history, and my learned friend Mr. Mitchell is quite right to say nowhere in the patent, in the prosecution history, do we say limited to. So I'll leave him to deal with that and not put my foot in it further. The second point that my own friend Mr. Alexander ran very briefly, we don't have a two-stage process because not a solid, it's a liquid to begin with. Lord, that is really swept up with the points that I've made already. And of course, as I say, as a matter of declaratory relief and the scope of what we're talking about, the fact that they ultimately have ended up there, it's not right to pass the issues here now. It technically makes no difference anyway. And he says, you know, the continuous dilution point covers a point for some patients. No, it's for all patients. So, my Lord, for all these reasons, we would say that the decision of the Court of Appeal is unassailable. If there's any further points that my Lord would like assistance on.
Thank you very much, Mr. Wall. Thank you.
But I would just, well, my friend says, just echo at the end where I started to say, although my learned friend has dealt with it quite briefly, it is quite an important point commercially.
Now, I understand that you say it can't be brushed aside even commercially. I understand that. Thank you.
My Lord, I intend to try and deal with the matters in the same order that my learned friend dealt with them, if that's convenient.
Thank you, Mr. Richardson.
First point, my Lord Neuberger had a question about the different levels of sales in France, Spain and Italy.
Yes, pure
and as we understand it, it's due to the differences in the incidence of cancer, particularly lung cancer in those countries. What one can think smoking is at a different level in France, for instance, than in the UK. Different methods of treatment, different, more aggressive levels of treatment in some countries, and also differences in the healthcare and reimbursement systems working in different ways in these different countries. So, for instance, it was only in December of last year that maintenance treatment with Alimta has been reimbursed in the UK under NICE, so that is an additional... I see.
So it's a combination of reasons. That's
yes.
very interesting. Thank you.
My Lords, on the merits, my learned friend started off with the patent, at Appendix Part 2, Tab 1. He showed you some paragraphs that describe the invention in general terms by reference to antifolates,
yes,
and in specific terms by reference to pemetrexed disodium. I've got two comments, if I may, on that. Firstly, the skilled reader would recognise that antifolates generally are not claimed in the granted patent. The claims refer only to pemetrexed. So the general wording regarding antifolates wouldn't impact upon the reader who's seen the claims.
Okay.
Were Lilly to be arguing that the claim covered a different antifolate to pemetrexed, then this point might be a relevant one, but that's not the factual scenario, so we say it doesn't make a difference one way or the other. And of course, what isn't addressed in the specification is the undisclosed middle, that is to say, other pemetrexed salts. And we say that the reader can't draw any conclusion from the specification that these pemetrexed salts are excluded merely because antifolates have in the end been excluded.
Yep.
Secondly, there's a distinction that sought to be drawn between single pemetrexed species and the more expansive descriptions of B12 and folate. If you remember, there are examples of the B12 and folate given. But with respect to all the patentee was doing, and the skilled person would understand this, was listing the known forms of vitamin B12 and folate. And given that pemetrexed disodium was the only form of pemetrexed which could be used in human trials, and therefore the only one mentioned in the specification, it's understandable. In contrast, there were, at the priority date, already other pharmaceutically acceptable forms of B12 and folate, and therefore the reference to either in the claim doesn't indicate any intention on the part of the patentee, objectively viewed, to exclude equivalents to other pharmaceutically acceptable forms. And so no conclusion can be drawn about the extent of equivalence for pemetrexed merely by the more expansive references to B12 and folate.
So your case turns on the fact that the other forms of pemetrexed weren't identified, although it was foreseeable that there might be some other forms.
Yes, my lord. And clearly, if the specification had mentioned
Which were usable.
pemetrexed dipotassium, and then that had not been claimed, then we're into the disclosed but not claimed doctrine that we've seen applied in Germany and in the Netherlands, and indeed referred to in the very original documents underlying the European Patent Convention.
You wouldn't have been able to claim it because you wouldn't have been able to show it worked. Is that right? I mean, if you mentioned biopotassium,
Well,
you wouldn't have been able to claim it because you wouldn't have been able to show that it worked.
I'm not sure I accept that, my lord. We wouldn't have been able to claim it because it wasn't mentioned in the specification. So we end up in this situation where...
but if it had been mentioned in the specification, would that have been a valid patent claim?
Yes, my lord, it would have been. Because,
even though you hadn't proved it to work?
Well, I certainly don't accept that a claim to pemetrexed dipotassium would be insufficient. If that's what your lordship is suggesting.
I'm just wondering, I mean, we'll go back to the subject. Your case is that you didn't mention these other things because it wasn't, they hadn't sort of been known to be, or tested and found to be usable. But you're saying that you could have claimed them, even though they weren't...
I accept that if there had been a reference in the specification to pemetrexed dipotassium, then we could have had a claim to that, and that claim would have been valid because our cases, and as the judge has found, it would have been routine to find that pemetrexed dipotassium was soluble, and the skilled person would realise that it was an immaterial variant.
I think the question is based on the proposition that you didn't know that dipotassium would work. It turned out it has done.
Yeah. Supposing it turned out it hadn't done, hadn't worked.
Well, if it hadn't worked, then we wouldn't be here.
No.
Yes, I'm sorry.
Would it have invalidated the whole patent if you'd claimed a whole lot of different types of pemetrexed, biopotassium is a good example, one example, and only some of them, or one of them, had been found to work?
That might have done, my lord, yes.
That might have been validated.
It depends on we get into tests of sufficiency, and the EPO says that if you have a single example in a claim where the claim refers to a group, then you won't lose your patent because a single one doesn't work. But if you have more than a trivial...
Yes, I see. So there would have been a risk in putting down a whole lot of other pemetrexed combinations.
Yes, I think it would depend how it was written.
Unless you tested them.
Unless
you've done the work to make them work. Make sure they work.
Yes, unless you've done the work. Yeah. That must be right. But that doesn't mean to say that we would accept that such a claim would have been insufficient, because, of course, we say it was trivial, as activists have shown, to think of another salt and then prove it's soluble. Obviously, a little bit more work is needed to actually get it into the patient.
How much work was needed to prove that it was soluble?
Well, my lord, the evidence was, I haven't taken you to it, there was some confidential tests, and I don't want to breach activists' confidence,
right.
But it's a standard setup with 24 hours. The stuff is left shaking for 24 hours, and then you measure the particulate.
I mean, on the face of it, it's not exactly rocket science to see if something dissolves in saline or water or whatever.
Indeed, it's absolutely routine.
Either it does or it doesn't.
Yes, and this is what the salt screening process that the judge referred to. You take a number of different
Can you
salts.
give us the reference to the page numbers without taking them? Don't look at it now. Perhaps your junior would be good enough to do
No, it's easy enough to find, my lords. It's in tab appendix part 2, and it's tab 36.
But these are confidential.
Yes, my lord.
Indeed, we're told they are on the first page. Fine.
Yes, and it's on page MS 1187.
Yep.
And your lordship can just see halfway down the page there that there's a particular pemetrexed salt referred to, and then there are some tests carried out, and you'll see
Well, we can see how it's done, yes.
Yes.
Thank you. Fine, well, if we refer to that, we won't. Yeah, okay. But certainly nothing in the judgment will divulge any of this information.
No.
Yep.
And finally, my lord, on the patent, of course, the Court of Appeal, as you've heard, found the claim was not limited to the solid form.
Yes.
And that's paragraph 74 to 79 of the judgment. So the skilled person looking at the claim would realise it covered the dissociated in liquid form as well as the solid form. And of course, that's exactly the same form as Actavis are now selling their product.
There's a slight element of having cake and eat it when we compare it with Mr. Ward's submissions, but I understand the point.
Well, my Lord understands the point. Our primary case is direct infringement.
Yeah, I'm not criticising. We assume you lose on this when we come to Mr. Ward's submissions. Yep.
And finally, of course, my Lord, I took you to the precise formulations of the Actavis products in opening, just to underline their product isn't the true diacid. No. It has a counter-ion. And so my learned friend suggested this morning, oh, well, we disclaimed the diacid. We don't accept that at all. And I'll come back to that later when we get to the prosecution history.
The diacid can't actually exist on its own, can it?
I think it may exist as a solid form. I think that's right. So
with hydrogen rather than...
Yes, and there was some...
I see. It exists as a... Yeah, what I mean is it doesn't exist as an ion on its own.
No.
But as an acid with hydrogen rather than sodium.
Yes.
Yep. Okay.
Yes.
Thank you.
So, my Lords, if I move on now to the historical analysis and just a few comments on the legislative history. My learned friend commented on the Laddie article, which is at AV4 tab 5. I don't think we need to go back to it now. And he suggested that the reference to the Morph report and the Halt reports quoted were relevant only to the ICC proposal in paragraph 72, which was rejected. And it's right that they are raised in that context, but it's clear from the text of the article that they were introduced to show the central objective behind Article 8.3 of the Strasbourg Convention and Article 69 of the EPC. And indeed, Professor Laddie refers to the Morph report as the decisively important Morph report in paragraph 73. And so all of the policy points that he takes from these reports underlay Article 69. Now, it's right that the ICC proposal that he referred to add material to the text of Article 69 was rejected, but that is what became the protocol. And he explains that in paragraph 78. So it was rejected as part of the EPC itself, but it was translated into the protocol to Article 69, and Professor Laddie explains that in paragraph 78. So, my Lords, we say this material is clearly admissible and helpful in pointing out the purpose of the original EPC.
Right.
In terms of the EPC 2000, and my learned friend Mr. Raphael's submissions yesterday, he attempted to suggest that there was nothing in the Travo to the EPC 2000 to suggest that Article 2 would require any change to the UK approach. Now, with respect, that's entirely unreal when you look at the documents that he took you to. And can I take you just to a couple of those documents to make this point good? So we need Authorities Volume 2 at tab 20.
Okay.
And this is the minutes of the meeting of the Committee on Patent.
Which flag?
20.
Sorry, tab 20.
Yes.
I remind you of this was the basic proposal to that committee, and I remind you of paragraph 228,
Yes.
where the UK delegation said it was an interesting proposal, diplomatic terms, which constitutes a radical change to the legal position in the UK.
Interesting is like Sir Humphrey's courageous, is it?
I think it might well be, my Lord, yes. And then we see the reference to the Epilady case below, the divergent rulings in that in paragraph 229.
Yes.
And just so your Lordships have the full picture, of the cases that took place around Europe in respect of Epilady, there was a finding of non-infringement at first instance in the UK. That's Mr. Justice Hoffman's decision, which you've looked at.
Yep.
There was also a non-infringement finding at the Court of Appeal level in Austria.
Yes.
But there were findings of infringement at the Court of Appeal level in Italy, the Netherlands, and Germany.
This was in the Epilady.
Epilady, which is the
Improver, yeah.
That's the Improver case.
Italy,
the Netherlands, and Germany, all at Court of Appeal level.
right?
So one has to be slightly careful with Mr. Justice Hoffman's commentary at the end of Improver.
Quite.
Because he's referring there to the interim injunction decision in the Court of Appeal in Germany, which did indeed lift the injunction. but the trial went the other way, and the Court of Appeal eventually found infringement as well. So his comments were made before those decisions, so understandable, but one has to be cautious about taking them as representing the full gamut of litigation across Europe.
So which were the jurisdictions which you mentioned a moment ago where there was no infringement?
No
Austria
infringement.
and UK.
Austria and UK, my lord.
And it went to the Court of Appeal in Austria, but not in...
It did, and we haven't got the Austrian case before you, but to summarise, the Austrian court said, if you've taken this long to explain why it's equivalent, it can't be equivalent. They sort of took a view as the length of description in the evidence and the number of steps that had to be said to be taken to get from the helical spring to the rubber rod.
Sounds like a happy shortcut, right? Okay.
But we provide that decision if your lordships need. And so, my lords, given the acknowledged divergence,
So in this case,
the insertion of text which expressly requires the courts of member states to take account of equivalence, there's only one sensible conclusion, which is that was directed at the countries where non-infringement had been found in order to encourage them to give patents wider scope.
The proposal referred to in M2655 MS, that paragraph 228, the interesting proposal. Just remind me which one. Is that the final wording or not?
It's almost the final. I was going to take you on and just make sure that...
it's the wording on page 2652, isn't it?
It is the wording on page 2652, yes, my lord.
Well, it's the wording we eventually...
Yes, that's so it's the time of the alleged
Yeah,
infringement.
it's the wording we end up with. I think it's on 2659.
Yeah.
And so, my lords, we say it's completely unreal to suggest that this wasn't added in order to encourage more courts to find infringement, and that, we say, is reflected by the UK's reaction to the proposal that we looked at in paragraph 228.
2667, I think it is.
Yeah.
Now, my learned friend said, oh, well, you shouldn't really be looking at this because this is only the committee on patent law, and you should really be looking at the conference. So if your lordships turn to tab 23, you can see the form of the proposal as it went to the conference, and you will see that it is on page MS 2669 in substantially identical terms. Certainly no material differences. And can I just turn your lordship's attention to page MS 2668, which was the explanatory text that went to the conference itself,
Yes.
which is very similar to the text that you saw previously in the
Yes.
patent on committee law, Committee on Patent Law, and your lordships will see, just scanning down, again, it's suggested that harmonisation is required because thus far rules of interpretation were not uniform. The significance of equivalence is put in bold in paragraph 4, and then you'll note at the end that the proposal had been approved by the 10th Symposium of European Patent Judges. So, my lords, the same policy reasons being pushed through to the conference as were already aired at the committee. And my lords will recall that there were two proposals put forward by the UK, and this is the document at tab 27. At the conference, the first proposal was to have no amendment at all. That was proposal A, to withdraw everything. And the second proposal was to a sort of diplomatic compromise, which is in fact what we ended up with in Article 2. The commentary that accompanied this, our submission is this really goes exclusively to option A. This is the reasons why the UK were giving why there shouldn't be any reference to equivalence. And I draw your attention particularly to paragraphs 5 and 6, paragraph on page MS 2696, which seek to try to distinguish between the intention of the patent drafter and the view of the skilled person. And we say, particularly bullet points 1 and 4 in this case, could almost have been written by Actavis in their written submission. So we say the UK was here trying to counsel against any equivalence being included, but they lost the vote on that. And then if your lordships also might be interested to look at the comments on prior statements.
We've already looked at that,
Yes, indeed, paragraph 8. And we see the form that was proposed at B. And then finally, we see at tab 30, and sorry, just in relation to the prior statements proposal, Article 3, your lordships will note that what the UK suggested was that there should only take into account statements unambiguously limiting the extent of protection, and only where the limitation was made in response to a citation of prior art. Now, I accept that this wasn't accepted,
Right.
but Your Lordship will see the relatively narrow scope that was proposed.
What page was that? That was
Bottom of
Page-
2697.
2697.
Yep.
My Lord, yes. And then finally, my Lords, in tab 30, this was the minutes of the meeting
Yes.
of the conference itself. My learned friend skipped over one paragraph, just on
Paragraph.
page MS, it's paragraph 171, the top of page MS 2709. And your Lordships will see that having lost the first vote and arguing about the form of the wording in Article 2, the UK did at least say that the term element would be more appropriate in the context of chemical invention. So it's clear there that the UK and the conference, we would say, was contemplating that equivalence should be applied to chemical inventions just as any other. Well, those were my comments on the legislative history. The next topic is the law here too, and your Lordships, we started with Catnick, and my Lord Neuberger queried whether it was safe to rely on Catnick when it was pre-EPC, and certainly we would suggest caution should be exercised in relation to any suggestion that the UK just happens to have been compliant with Article 69 in the protocol since before the EPC was written. But we do say that certain principles of the old UK law are still applicable, and we note in our written case at paragraph 68 that Lord Diplock had said in the Beecham case that pith and marrow was the same as the doctrine of equivalence. And it's for those reasons that the expressions of policy that the House of Lords made in Van der Lely, Rhodey and Beecham in the 1960s and 70s, and in Catnick, we would submit apply equally today. And those expressions of policy we've seen repeated in the Laddie and Meyer-Beck articles, but they are significantly missing from Lord Hoffman's discussion in Amgen. And that's, we say, what is wrong with the UK law now is that sufficient attention has not been paid to those factors. Now, as far as harmonisation is concerned, we acknowledge that a number of the higher courts in countries applying the EPC are striving for harmonisation, and that is obviously a good thing. But we note that that can cause complications where one court may try to cross-refer to another if the original court was not, in fact, using a test that's EPC compliant. And we also note that within a single case there can be complications, for instance, where one court is seeking to justify its agreement with another, such as the Swiss decision in this case, trying to align itself with the Court of Appeal decision that had been made here. And we do submit that in places such as Germany, where the number of patent cases is so high, so much higher than any other country in Europe, these provide a robust cross-check to the right sort of approach that should be adopted. And of course, we rely specifically on the German court's conclusions on question 2 so far, and the Bundesgerichtshof's conclusions on question 3 on the facts of this case. We do accept that the Netherlands is also a respected jurisdiction, but we would submit that there are mixed messages from the Dutch material that you have before you. My learned friend relied heavily on the opinion of Advocate General Van Persum.
Yes.
But we don't see any of his policy reasons coming through in the Supreme Court decision. So with the greatest respect, his opinion should be accorded similar weight to an article by Professor Meyer-Beck or Professor Laddie. It's that sort of level of discussion. And my lords will note there was a useful table in that decision. It's I don't think we need to turn it up now, but it's AV5 tab 13 on page MS 4685, where the Advocate General notes the divergence in the reference date used in the various countries. Perhaps if your Lordship's interested, it's tab 13.
Yes, I've got it. Yep, thank you.
And the Advocate General notes the difference in the reference date used for question 2 and the use of the granting file. And indeed, he suggests that the relevant date in France is the date of infringement. And he notes that in France there's no consensus on prosecution history. He also notes that the prosecution history is not used in Germany, which is in fact consistent with the evidence that the experts gave in this case. Their agreed memorandum recorded that there was a dispute about whether you can look at the application as filed,
right,
but the prosecution history itself was not looked at.
Thank you.
And we also have the commentaries from Advocate General Hoyde Cooper at tab 10, which we say, if you're going to read some of the Dutch material, that's useful to look at as well. And on page 4.5...
That person refers to this, doesn't he?
He does, indeed.
Yep.
And on page MS 4577,
Yep.
the Advocate General in that case notes that the room for interpreting outside of the text in the UK is quite limited. We say he's correct about that, and that's why the UK is not in accordance with the protocol. And then he goes on at paragraph 44 of his opinion to make the point that you shouldn't double count. You shouldn't take into account equivalencies in construction and then apply a separate doctrine. And we accept that would be wrong. But we say that the reverse is the problem now in the UK. In other words, construction takes place, the exercise of construction takes place with the focus heavily on the language. And then once the exercise of construction has taken place, following Amgen, they say there's no need for an equivalence analysis to be carried out because it's already been carried out in the construction process. So, of course...
But to some extent, it depends on the Netherlands Advocate General's view of what is meant by construction in Lord Hoffman's speech.
Yes, indeed, my lord. But just as it's wrong to double count,
No, of course.
we say, of course, you can't ignore...
Wrong to ignore, yeah.
Yes, indeed.
If you give interpretation a narrow or traditional meaning, then you should have equivalence. If you give it a wide meaning, then equivalence would be double counting.
Yes.
Yeah, okay.
And we also noted that the article by Rian Calden at tab 7, particularly pages MS 4383 to 4385, in relation to the approach in the Netherlands, which we say, I refer to that in my opening, we say that is also informative. And
That's in bundle 4?
That's in bundle 4, my lord.
Yes,
Yes,
we looked at that, yeah.
we did, yes.
Yeah, thank you.
My lords, in terms of the other jurisdictions, I'm afraid, with great respect, we do differ in relation to my learned friend's submission as to Switzerland and the Swiss patent courts. No doubt Switzerland has a thriving pharmaceutical industry, and that is obviously important. But in the end, it's the number and quality of patents court decisions which are important in establishing its preeminence in that field. And neither Mr. Warren or myself are aware of any Swiss decision ever being cited in a patent case in the UK, in our experience. And that may be because the Swiss Patent Court is only 5 years old, the Specialist Patents Court. And so there's only a limited number of decisions so far from the Specialist Patents Court in Switzerland. And of course, the decision at AV5 tab 23 is only an interim injunction decision. Now, I do accept, of course, that there is a further decision at tab 23A, decision on the merits. But if you read it, you will see that it is effectively a cut and paste job. No disrespect to the judges for that, but it is
decision.
Of the previous decision.
Well, I did seem to be echoes, yeah.
And if your lordships were to look at it, I would like to make the following observations on it. So it's at tab 23A of bundle AV5.
Yep.
And I'm sorry to make you look at the second decision when my learned friend made you look at the first, but there are a couple of differences in language that may be of importance. Firstly, my lords, on page 4949K,
Yes.
your lordship will see the traditional European approach, looking at literal infringement first, and then on 4949L, they turn on to equivalence.
Yes.
And then the core of the decision in the Swiss court is 4.5.3, limitation through the prosecution history, on L.
Yes, yes.
And then if we go on, please, to the bottom of N,
Yep.
the court there refers to another decision
Yes.
in the Court of Zurich. And then if your lordships would just read the first two paragraphs on page O, please.
O or N?
Please, yes, the next page after N, starting with the commercial court stated.
Sorry, that's the long paragraph and then the
Yes, please.
shorter is followed, yeah.
Yes, please.
So it is effectively file wrapper estoppel.
Yes, I mean, the important point for our matter, my lords, is they say explicitly this is nothing to do with the EPC. They say this is a doctrine of Swiss law, the limit of good faith under Article 2, and they say that it's not really a patent law matter at all. And so it's special to the Swiss jurisdiction.
Yep.
If your lordships then turn on to page Q, and you'll see the conclusion of the Swiss court in the paragraph just between the hole punches, since the limitation.
Yep. Yes, I see.
And then it's right that the court goes on to regard equivalence at the bottom, starting at the bottom of Q, but, my lords, we would say that's strictly obiter in the light of its decision thus far. If we pick it up on page R, we see them addressing the protocol type questions, and the second and third paragraphs on page R, perhaps your lordships would just look at how the Swiss approach that.
What, for the assessment?
Yes, my lord.
Yes.
And then, my lords, on question 2, their conclusion is on page T. Just at the bottom, one can take it just above the hole punch, the patent in suit provides no basis. Perhaps your lords would just read that paragraph down to the bottom of the page.
Yes.
So their finding is that the solubility issue could be solved with reasonable experimental effort, and that's why they answer question 2 in Lilly's favour.
Yes.
And then finally, on page U, and my learned friend did take you to this.
Yes, he did.
The reasoning at the bottom of U, and then over the page to page V, they rely on the Court of Appeal at the top of V.
Yes.
And then they say that there is a limitation. But as my Lord Sumption observed, there are no reasons given for the limitation.
But you would say this is a bit like Lord Hoffman saying, going through the motions, but ending up saying because it says disodium, that's the end of it.
Absolutely. They haven't given room for equivalence at all. They've referred to the specific single substance.
That's your argument.
My Lord, yes. And so we say for the
Yes,
same
understood.
reasons.
Thank you.
And of course, this decision is, there's a right of appeal in Switzerland, and Lilly are appealing this decision. So just to update you as to the...
Yeah. Yeah.
My Lord, so that takes us on to what is the correct approach under UK law today and the EPC.
Thank you.
And you have my basic submission that the application of Article 69 in the protocol cannot easily be said to be a unitary process of construction. Whatever you call it, whichever box you put it in, there are 2 necessary steps.
Yes.
You have to work out the meaning of the words in the context of the document as a whole, at the priority date and within the 4 corners of the language,
yes,
as understood by the skilled addressee
yes.
with the CGK. And then you ascertain the extent of protection within the meaning of Article 69 in the protocol, achieving the necessary balance between the literal meaning of the wording, which you've already ascertained, and a general description of the invention, which merely uses the claims as a guideline, and this must include giving due account to equivalence. And giving due account to equivalence may well involve asking whether the variant is a variant to an essential element of the invention or not.
Again, that slightly begs the question. Sodium is surely, it could be said to be an essential element in this case, because you need to have an element which enables it to be dissolved.
But that's not essential to the invention, my lord. The
But it
invention
is, isn't it?
is
Because it needs to be in liquid form, so you need to get it dissolved.
well, that's the debate that we've had.
But it's true.
It's true that it needs to be in liquid form. I of course accept that. But the invention is nothing to do with getting pemetrexed into liquid form. The invention is about combining pemetrexed with vitamin B12 to alleviate the toxicity without losing efficacy.
But in order to give that effect, you have to have the pemetrexed in anion attached to a cation in solid form, which enables it to be dissolved in saline.
You do, my lord, but we would say that the salt is equivalent to the overheating issue in Improver. It's obviously you can't sell a product that overheats when you use it, and so it would be useless commercially. And you can't sell a pemetrexed salt that isn't soluble. It wouldn't work. But the question under Improver is not whether it works, but whether it works in the same way as the invention. And that's what the judge and the Court of Appeal have lost sight of here. They've placed too much emphasis on this solubility issue, which is, it's part of the claim, of course, and the product has to be soluble to be used, but it's not an essential part of the invention. And it's a bit like the bottle in, your lordship may recall the facts of Schutz.
I do.
And the bottle, there was a difference between the importance of the bottle and the cage, and although the bottle was an essential part of the claim, it wasn't an essential part of the invention, and that's why your lordship found as he did in Schutz. And we would say exactly the same here. The salt form is not important.
So does that mean that any use of pemetrexed anion in solution with vitamin B12 would infringe whatever the cation was?
Well, if there had been a claim to and pharmaceutically acceptable salts thereof, we wouldn't be here because Actavis would have no defence. In other words, there's no objection.
The claim isn't to that.
No, I accept that, but I'm putting to my lord that there's no objection to a claim which covers the versions that work.
Because it's the inventive idea is the addition of vitamin B12.
Yes, and it would be trivial to find the other salts that work.
Isn't that a dangerous point for you? Because it might be said, well, then why didn't you claim that if that's what you wanted? Why did you claim the sodium ion only? It must be because that's all you wanted.
Well,
if you could have claimed more so easily and so obviously, why didn't you?
That's what I call the reds under the bed argument, which is, well, there must be some reason for you limiting yourself, and therefore you should be held to that limitation and no equivalent should be found. My lord, we don't accept that.
Well, I know you can call it reds under the bed and say you don't accept it, but why not?
Because there needs to be a reason, with Article 2 in mind, there needs to be a reason to limit the claim so as to exclude any variant, any in italics.
Your answer is ultimately you claim one, knowing you can fall back on equivalence.
My lord, yes. And you're not doing proper justice to Article 2 to exclude those equivalents merely because you've written in linguistic form a particular salt.
And then you say, standing back, is it right to give you the whole gamut of pemetrexed salts, whatever the cation, if it's used with vitamin B12? And you say, given the nature of the claim invention, yes, it is.
Absolutely. This is the archetypal non-essential element, the salt form, because the invention is nothing to do with the form of the salt, the form of pemetrexed.
And if somebody has a brilliant new idea about a new cation that has the use of a cation with pemetrexed that has some unusually beneficial effect, then we would be into a sort of a nesting patent. They would claim that, but they'd also, whoever wanted to do it would also have to.
Indeed, we'd be into the Amgen, looking at the inventions that perhaps couldn't have been contemplated at the time of at the priority date.
But where are we then with that? Let's say some completely unexpected cation was discovered to work with added benefits. That could be used on its own without infringing your patent, but the moment it was used with
pemetrexed,
with B12,
yes,
then the person concerned would be infringing your patent because it was B12 and the patent of the person who discovered the new cation and patented that.
Indeed, because they are taking advantage of our invention.
And of the notional invention.
Yes.
And in that event, you wouldn't pass question 1, would you?
If it didn't work at all?
No. If it worked with superior and additional benefits, then the answer to question 1 would be that the variant did have a material effect on the way the invention worked.
But would it
So
have a...
the variant would be outside the claim.
Well, the variant would be, but the question would be if you were using it with vitamin B12.
Yes, it depends.
If
It would
it
depend
needed,
whether...
if it needed vitamin B12, if it was just much more effective at dealing with cancer, but had the same side effects as sodium pemetrexid, so you needed the B12,
Yes,
you would be infringing both the new patent and your patent.
yes, indeed. And of course, in Improver, the defendant in Improver had their own patent on the Improver, on the Epilady product, and that was...
So you would say there would be, in those circumstances, you would pass the first Improver test?
Yes, it would obviously depend precisely on the facts and what the additional benefit was, and if there was an additional benefit that was relevant to the invention, that might be...
What I'm envisaging is that the cation somehow does contribute to the way the pemetrexid works. Hard to imagine how that might be, in the sense that it just becomes much more effective at inhibiting cancer cells.
Yes, but if the B12 was
but
working
you
in the
still
same
need
way...
the B12
Yes.
in order to stop the side effects.
Yes, absolutely. We would say the B12 is working in the same way to alleviate toxicity, then that's good enough.
Yes.
And my lords, we say the relevant person to whom this question should be addressed is the person with the practical task of putting the invention into effect, as Lord Diplock pointed out in Catnick. In this case, it's primarily the oncologist who doesn't care about the salt form. He's just interested in the pemetrexed. And as Lord Justice Aldous put it in Wheatley and Drillsafe at paragraph 23, it's reasonable to infer that the patentee intended to include immaterial variants and exclude material variants. We say that is in accordance with Article 2. That's precisely what the court should be looking at. And plainly in this case, the sodium is not essential. It's an immaterial variant. The important part is the pemetrexed and the B12. You need to have a cation, but it doesn't matter which one, particularly when the skilled person can see that the claim covers solutions as well as solids. So
I come back to my point. You say that it's an immaterial variant. I think it's why Lord Sumption said it wouldn't pass the first test, because on my analysis, my example, the cation does have an effect, unexpectedly.
it depends effect on what, my lord. If it has an effect on the way the invention works, that might be relevant, and that might mean that you fail question 1.
The invention works on, so you'd have to look and see whether it worked better because it helped the B12, or whether it was better because it helped without or with the B12, the pemetrexid.
Absolutely.
It must have an effect on the way the invention works if it produces a significantly better therapeutic outcome.
Because the invention isn't concerned with better or worse therapeutic outcomes. It's concerned with stopping side effects.
Toxicity, indeed.
Yes,
so if the
Right,
toxicity...
well, a significantly, an even lower level of toxicity.
Well, if that was the case, then that might be relevant to the way the invention works.
Yes.
And that could be a relevant point. But of course, in this case, there's no...
Still been it would be taking your patented, on your case, it would be taking your patented item or treatment and improving it. But
Yes.
it would be improving something that you'd patented.
Yes.
Putting
But
putting an extra wheel on a car and making it run faster wouldn't stop you infringing the patent of the car.
Absolutely not. That's settled. And of course, this is the irrelevant debate that took place in Improver as to whether the rod was better at plucking the hairs. Irrelevant, we say. Well, that's an example of where the debate might arise. But in this case, there's no suggestion at all that the salt form makes any difference. And that's why activists...
I'm just concerned if you're right, seeing how far it goes, that's all. Back to this case, I see it quite simple.
I notice you quoted our Lord Justice Aldous in Wheatley and Drillsafe. He was, in fact, dissenting. Probably
he came second,
the
my lord.
majority judgments you probably think took too narrow a view of the too constructional approach.
Well, with respect, my lord, as I recall it, your lordship agreed with Lord Justice Aldous on the law. and you dissented, or no, he dissented from you on the facts.
You put it right the first way around.
And so, my Lord, I didn't detect there was any tension between members of the court on that comment in paragraph 23. Now, my Lords, we've put forward our EPC 2000 questions as being a suggested way to deal with the issues under the Article 69 in the protocol. We don't pretend they're the only way that the exercise can be carried out.
Sorry, what are you referring to now?
The form of questions, the EPC 2000 questions that we had in our written case, my Lord. Yeah. But we certainly suggest they represent a better guide than the improver questions, or Amgen, as currently applied in the UK. Now, I don't think I need to spend any time on question 1, which is...
Wait, remind us where they are, sorry.
My Lord, they're in our case.
Yes, I know.
And they're also on a paper that I handed up.
Oh, yes. This looks like that, yes.
It does, yes, my Lord.
Got another copy of that by any chance? Mine seems to have disappeared.
Yes, that's the trouble with bits of paper that you hand up, my Lord.
There's my note.
I'm sorry, my Lord, we seem to have run out on this.
Don't worry, I will.
Share with me.
Yep.
It's para 161 of our case on page MS 251 at 10.
(161), yes.
161.
Which you slightly added and changed a bit, but those are basically the same.
They haven't intended to change them, my Lord. They should be the same if...
Just to sort of flesh them out, Anyway, yep.
So, my Lord, the question 1 is the version of question 1 that Lord Hoffman referred to in Amgen, which is the German version. I don't think we need to spend time on that.
And it's the way the invention works, not the way that, in this case...
The variant works. And my Lord, that's absolutely clear from improver onwards. Right. And so my learned friends, with respect, misspoke yesterday. They kept referring to, does it work? Does it work? It's not whether it works, the variant, it's whether it works in the same way as the invention. That's the crucial point for questions 1 and 2. But yes, question 1, your Lordship's right, does it work in the same way as the invention? Yes. Does it solve the problem in the same way? Is the function and the result the same in the various ways that it's put around Europe? My Lords, question 2, I remind your Lordships that no other court has found against Lilly on question 2 except the English court. So we have 2 German courts at first instance, German Court of Appeal, although they didn't address question 2 expressly, they did say it was discoverable, which would comply with question 2, and the Swiss courts.
Just looking at question 2, that asks whether the answer to question 1 would have been obvious at the date of the alleged infringement, which, as expressed there, would be quite difficult to reconcile with the proposition that it's a question of construction. Now, one possible way of looking at this, I just raised this hypothetically, is to say that what has to be obvious to the skilled addressee is not the impact of the variant, but the immateriality of some element of the description of the product or the process in the claim. You can test that by taking as a hypothesis the infringement that actually and possibly unpredictably occurred years later. But the essential question which the skilled person is being asked is there, in this case, is the disodium, the use of the disodium compound, immaterial? Not, is it obvious that some alternative would work? The latter is simply a way of hypothetically testing the answer to the question you can actually pose at the date of the patent. Do you follow me?
I think I accept that. That must be another way of putting it, my Lord. It's whether...
What's the difference between that and the third question, then?
Well, that may be, I mean...
Well, the third question reverts to the claim to ask whether there is something in it which requires you to treat that which is immaterial as nevertheless being essential.
Yes.
Which is, I think, a different question. But you say one could put it that way. Is it a way which, in your submission, is open to objections because it's different from the way you formulated it?
Well, my Lord, I think it addresses it more as a point of construction, as it were.
Yes,
You're
exactly.
doing it in the absence of the infringement.
I mean, the reason I put it to you is that it may be possible to, you may end up reaching the same answer to question 2, even if you frame it as a question of construction, provided you're reasonably precise about what the question of construction is and what the role of the future variant is in that process. I mean, your formulation requires one to abandon the notion that it's a question of construction. And I just question whether that is necessary in order to get the answer that you need to question 2.
Yes. My Lord, I think some judges have characterised questions 1 and 2 as fact-finding, and then question 3 being the ultimate question of construction, which you try to address having found the facts as to what your variant is. Others have addressed them all as questions of construction. And there is also learning as to whether or not you can assess infringement generally without the infringement in hand.
Yes.
And although I think Lord Justice Jacob has recognised, I think in Technip, that theoretically you should be able to do it without the infringement in hand. It's much easier to do it when you know what your target is, because you don't waste pages of judgment worrying about things that
You're
you know.
effectively using the future infringement as a hypothetical state of facts with which to test what would be obvious possibly at some earlier stage.
Yes, yes. But we do make the other submission, which is that for any tort, you judge the tort at the date that it takes place. And it is a little bit artificial to be prevented from feeding any information that occurred after the priority date into the decision as to whether something infringes or not. And this goes with the prospect of a claim with measurements in or testing in. You have to do something. You may well have to do something at the date of the infringement to work out whether you infringe or not. And so it's just artificial to say that no information could be fed into.
Yes, well, that's not implicit in the formulation I'm putting to you, because you certainly do ask yourself the question by reference to hypothetical facts corresponding to what the alleged infringer ultimately did.
Yes, I think the problem, my Lord, I don't think it makes any difference in this case, because we say it's obvious at the priority date to come up with another salt. But the difficulty is if with a future, a later development which wasn't foreseeable at the priority date, does it make it more difficult to cover that sort of example?
Well, if you had a situation at the priority date where the person skilled in the art would say, well, you can't do this with anything other than disodium, well, then your position would be very much more difficult.
Yes.
Your real point is how much does jumping forward to the date of infringement or jumping back from the date of infringement, how much do you carry jumping back? Do you just carry the infringement back to the date, the date of infringement? Do you just carry the actual infringement back from the date of infringement to the date of priority date and judge everything else by the priority date? Or can you carry common general knowledge back from the date of infringement to the priority date on your basis?
Well, we don't need that in this case.
No, but what's your answer?
And in the Netherlands they do. It depends whether it's a matter of construction. I think matters of construction of the patent are seen through the eyes of the skilled person
As at the date of
the priority date. And if that's the point that Lord Justice Floyd took, that if you are importing knowledge that wasn't available, then if potentially
you can't change its meaning. That's the point.
Yes, indeed. And I think we accept and embrace that. We're not suggesting that the meaning of any words changes as a result of the doctrine of equivalence. The meaning of the words is the meaning of the words. In some cases, it may be that an equivalent is only possible to derive 5 years after the patent was applied for. And those are difficult cases. We accept
If, for
that.
instance, to take a somewhat absurd example, a new element, atomic number 120, was found that wasn't, in fact, completely self-destructing the moment you found it, and it worked particularly well, but that was only found after the priority date.
We would say that in an appropriate case that would be covered.
And yet, if you go back to the priority date, people would say, what is this? Never heard of it.
Yes, it depends a little bit how the term of the claim is. If the claim
That
refers
is
to
the problem.
alkaline
It all
salts
depends-
and
it all
is an
depends how you
alkaline
tell
salt,
them.
yes.
Yep.
Yeah. But my lord, even with your lordship's proposition that you just take the infringement back with you, it depends what you mean by the infringement, because if I have the bottle of
I mean, the
Actavis
alleged
product,
infringement,
yes, but if I have the bottle of Actavis product in front of me, I can see it's soluble. There's no, I
that-
don't need to get into any of this.
Right.
If I have that information, if I only have a piece of paper which says this is what Actavis proposed to do, then I may have to do a routine test to find it soluble, and that's where we have to get into that discussion.
And even obvious to try begs the question, because is it obvious to try as at the date of infringement, or obvious to try at the date priority date?
Yes,
But you say that's not the test.
That's not the test, and that's
Then
not.
either of you are.
It's not relevant in this case,
No.
and as far as we're concerned, it's common general knowledge, as the judge characterised it. That his paragraph 60, I think, where he says, "Oh, common general knowledge includes routine things such as finding solubility." And so you can characterise it as common general knowledge that would have been available to the skilled person at the priority date, or you can characterise it as routine, straightforward tests, which would clearly be obvious. And we've cited Hospira and Genentech as being a recent case in the Court of Appeal where it's clear that it doesn't matter if you don't know what the result of your empirical test is going to be. If it's obvious to do it and you have a reasonable expectation that something will work, the fact that you don't know in advance precisely which salt form is soluble, or in that case it was to do with a formulation of Herceptin, it doesn't matter as long as it's all just routine, it's still obvious. So, my lords, we say we win on any basis with all respect.
But as soon as you suggest that, or submit that you can simply carry back the knowledge of what the actual new proposed method of operation is, even though it's not foreseeable, might have arisen from the discovery of some new element later on, so it's not a matter that would have been foreseeable at all. You're departing from any known canon of construction, aren't you?
If that is if it's going to be called
construction.
That's why you say it's not construction.
That's why we say it's not
I
construction.
mean, construction only works if you're talking within the framework of what is foreseeable or what is within general knowledge easily ascertainable. Then it's part of the background in traditional terms and can be taken into account. But
Yes,
you're going further than that.
I'm not going further. No,
That's why you're saying it's not.
yes, we're not suggesting that any doctrine of equivalence allows the meaning of words in the claim to change. That's not our suggestion at all. The meaning of the words is the meaning as at the priority date.
Obviously that's the starting point. You ask, what do these words mean? And then there's a separate question. Is this an equivalent?
Indeed. And that's
material purposes.
And that's where, in some cases, it may be relevant to take into account later acquired information. We say that's not this case, because this case, it was obvious at the priority date, and you don't need to go any further, even if you have to ask the question at all, because you haven't got the thing in your hand. But there are other cases where later developments may not have been foreseeable, and that's...
Can you just tell me, you referred to Hospira and Genentech, just remind me which paragraphs it is. Again, don't take up time now, somebody can...
I can do that, my lord. It's tab 18.
Yeah, I have it.
And the relevant paragraphs of the law at the beginning are particularly paragraph 13
Thank you.
and paragraph 16.
It's bundle 3.2 authorities.
And then...
3.2 in the authorities.
Yes, and particularly the quote from Lord Justice Jacob...
It's paragraph 16, yeah.
Paragraph 13, there's the second half of the quote
Yeah.
from Novartis in generics. I reject the submission that the court can only make a finding of obviousness where it is manifest that the test ought to work. And then 16. And then the judge's application is also of interest. That's at paragraphs 51 and 52, where he talks expressly about it being unrealistic that you should have to predict in advance.
Thank you.
Because otherwise that would exclude patents in this field.
Tab 18, 3.2. Thank you.
Yes, my lord.
Yep. Sorry. Thank you.
And so, my lord, getting back to my learned friend's submissions at least, we say it's not right to ask simply, does it work? The question is it obvious that it works in the same way as the invention, or that it solves the problem underlying the invention by means which have the same technical effect? And we point to Improver, where Mr. Justice Hoffman made it clear it wasn't simply a case about whether it worked. The rubber rod was assumed to have the qualities it needed in sufficient degree and to be without defect,
Very well.
such as overheating or falling to bits. These are necessary requirements to work, but they weren't relevant to the invention. And we say, as here, the salt form is not relevant to the invention, which is all about B12.
Yep.
And we submit that that is made clear, in fact, by Lord Hoffman in paragraph 83 of Amgen, where he distinguishes between the various types of test and patent. And we say it is more helpful to feed in the later information as to the nature of the variant to allow the court to focus on whether or not it's equivalent, just as you would look at a breach in a contract dispute to decide whether or not it is a breach. You're not changing the construction, and having the infringement in front of you is necessary to determine if it infringes literally, and you must be allowed to carry out whatever tests you need to do for the claim to establish that. So there's no conceptual difficulty in also having it in front of you to determine whether it's an equivalent. And we would rely on the fact that in this case, the claim requires the product to be a medicament. So if you've got to question 2 at all, it must be a medicament. And if it's a medicament, it must be soluble, because the common general knowledge was that pemetrexed had to be given intravenously.
Well, you adopt what Lord Justice Floyd said on that issue in relation to indirect...
My lord, yes, we do.
Yep.
We do. And another way to look at this, as we've discussed, is to ask, is the variant part inessential or not to the invention? And we accept that is another way of approaching it. And if it's inessential, then it doesn't matter if you know whether it works or not, as by definition it's not going to affect the invention. And this is perhaps a way to deal with the problem type case like rapamycin, where Lord Hoffman said it begs the question to ask whether it works or not, because the invention is all about whether it works, whether the new molecule works. So we can deal with that by simply saying, is this different molecule an essential variant or not? And in that case, the conclusion would be on the evidence that it was an essential variant, because you had to do clinical trials to work out whether it worked, and the patent didn't actually tell you how the invention worked. So the reader was left in the dark as to whether or not that variant would be effective.
Thank you.
So on that basis, you don't need to get into obviousness of solubility at all. If you do get into it, then we say that we win too based on the evidence found by the judge. My learned friend accepted that it must be a matter of degree as to how much the skilled person is allowed to do when answering question 2 yesterday. And in the judgment, can I remind your lordships of paragraphs 81 and 82, which is Core Volume 2, Tab F. Firstly, paragraph 81, where the judge referred to the 2 standard textbooks listing salts, Burge and Stahl and Wearmouth.
Yes.
He lists the most common counter-ions, but the ditromethamine was also listed in those books. And just so your lordships are clear, there's nothing particularly unusual about ditromethamine in spite of its long name. It's the same as tris. Yeah, and my Lord Neuberger might recall from earlier days tris buffer, which is a standard buffer used in biological systems and biological experiments. That's ditromethamine. So this is a standard buffer, and the evidence, there was evidence on that it was a standard buffer, and it was found in the textbooks. And then in paragraph 82, the judge explains it's an empirical exercise to work out which ones are soluble, but the chemist would have a reasonable expectation of being able to find a suitable alternative. And so we say if he's carrying out his routine screen and he's expecting to find ones that work, then he would come up with dipotassium, ditromethamine, because they are standard salts listed in the books. And the Munich court found question 2 in Lilly's favour for exactly the same reasons. For your Lordship's note, it's at bundle A-fee 5, tab 5, on page 4481. They rely on precisely the same textbooks as the judge relied on, Burge and Stahl and Wormuth, to explain that the ditromethamine was standard and routine, and we've looked at the Swiss decision as well, which makes the same finding. Also, finally, my Lord, the judge held at paragraph 86 that the chemist would consider the diacid, just down the bottom of the page, and we
Yes. We've looked at those ones, yes.
Indeed, yes. And
Very similarly set out in the Court of Appeal as well, yep.
Yes, and we rely on paragraph 66 of the judge, where he sets out the solubility test for salts as being standard common general knowledge.
Yes. Thank you. Yep.
My Lord, finally on this topic, I think I should just deal briefly with Merck and generics, which my learned friend took you to yesterday, and just show you quite how extreme the facts were in that case and why it doesn't assist his argument here. It's bundle 3.2, tab 20.
Tab
24.
Thank you. Yes.
And if your Lordships would turn to page 3475.
Yes. Slightly before strategy.
This is Justice Laddie. This is pre-Amgen, and you will see the table of the claim 1 on the left-hand side.
Yeah, when one sees, yes, what he...
and you see all the differences, and Mr. Justice Laddie's characteristic...
22, yep.
Yes,
Cheshire Cat.
Cat
Different
smile.
sort of cat from Lord Mance's Angora cat.
Yes. And then in paragraph 26, he refers to the experiments that my learned friend referred to, and he explains the last sentence of paragraph 26, that they were said to address the first 2 improver questions, particularly the first one. So what the patentee was trying to do here was to show that it worked at all in the same way as the invention, let alone that it was obvious. And then he refers in paragraphs 30 and 31, he refers to the extent of the experiments.
Yes.
And he says in paragraph 30 there had to be 9 experiments carried out by Professor Scott, and there were 2 days of cross-examination on those experiments. So, my Lord, we say it's not surprising that he found as he did in this case on those facts. If we go on, your Lordships were taken to paragraph 42.
You say it was a bit like American Home Product in that sense, do you?
Yes, although, can I just make one comment? Paragraph 42, where Mr. Justice Laddie refers to the balance.
Yeah, we looked at that.
But then in paragraph 60, he goes on to say that in that case, the claimant is caught on the horns of a dilemma.
Yep.
If he asserts it's obvious that they'd work in the same way, that there are only 2 possibilities. Either the patentee should have written it in, or you deem them to be excluded.
Right.
And we say that's precisely the mistake, that not giving the policy underlying the EPC proper weight. There's no equivalent. You're effectively writing out equivalents altogether in that situation. And we say so that's difficult to balance with what he said in paragraph 42, which we accept is fair and appropriate. But we say this was a very extreme case, the experiments were of a totally different nature in this case to those the routine tests in our case, which we say would form part of the common general knowledge and were held to be routine by the judge.
Well.
So, well, that's question 2. Question 3, I think my learned friend yesterday accepted that the UK takes claims more seriously than other jurisdictions, and we say that is part of this is a very real problem, particularly when combined with a construction approach which requires the court to ask, is pemetrexed disodium the same as pemetrexed dipotassium? We say it's not. That's not how the test should be asked, and it's not surprising if you try and carry out.
We've been round this circuit.
Indeed,
It comes
indeed.
back. If you treat it as a matter of ordinary construction, then there's no room for equivalence. That's
Yes.
your point. Yeah.
And my learned friends, I say, Reds under the bed approach, you have to construe the claim narrowly just in case there's something out there which might invalidate, or just in case there's some other reason why the patentee wanted it to be construed narrowly, is unfair to patentees and unprincipled, and not in accordance with Article 2, which requires equivalence to be taken into account. And it's contrary to his later concession that you should take equivalence into account in every case. And in that respect, my Lord, we do adopt the observation that my Lord Sumption made this morning, that you need some reason to indicate that equivalents are excluded, other than the language itself. Otherwise, you're not giving proper weight to Article 2. My learned friend says, oh, well, there are three possible positions you could find yourself in. There's a purely technical reason why you exclude it, and as my Lord Sumption observes, that's question one. So if it doesn't work in the same way at all, then it's excluded full stop. The other two reasons my learned friend referred to, the assumption, even though you have no window into the soul, because there are possible reasons why you might want to exclude them, or you just can't tell at all, those are entirely speculative. And we say the balance is entirely one-sided. You are not giving proper weight to Article 2. You need a clear disavowal of equivalence in order to exclude them. And my learned friend's approach is akin to writing them out altogether. There is no contra proferentem rule in patents. There are ways in the grant process that require the patentee to write his claims clearly and concisely, as we've seen. That's there in order to make the claims comprehensible in the first place. And
How do you expect to find a clear disavowal of equivalence?
well, you can have a disclaimer, an express
That's pretty unlikely, isn't it?
Well, we've seen, in our written case, we referred to the section in Terrell that shows that disclaimers are in fact quite common in the European Patent Office. If a piece of art comes up in prosecution, then it's quite common for a patentee to write into their claim, but we don't cover X in order to maintain their claim as valid. So that is a common way of doing things. And other ways, plainly the patentee can write into the specification that there are certain groups of classes of product are excluded for this reason. And my lords, we say the doctrine...
I mean, some people might say that repeated references to permextred disodium was a clear disclaimer of anything else.
Well, my lord, that comes back down to the language argument we would respectfully suggest, and there's no reason to exclude other salts when they are inessential and they don't affect the way that the invention works. And there is no...
That's the argument which cuts both ways, isn't it?
Well, my lord, I accept that. You have to read the document and understand it, but our submission is that you do need a reason to exclude them because Article 2 requires you to take them into account. And this is really going back to Lord Diplock in Catnick, where he said no reasonable patentee would want to exclude these immaterial variants because his monopoly would be worthless. And we do say in this case, where it's clear from a regulatory perspective that you can alter the salt and make no difference to the active ingredient and you haven't got to do any clinical trials to achieve that, then this is a prime example of where the skilled person would say, well, I can't believe the patentee intended to exclude alternative salts because any generic could come along with an alternative salt and jump on the back of your data and come to market. So, my lords, we say this is as good an example of any where there is no good reason to exclude them. In fact, there's a reason to include them. But in any event, Actavis haven't met the standard which Article 2 requires, which is you give due account to equivalence unless there's a reason not to, and there is no clear reason in this case. And this is really the perils of the exclusio unio rule, which I've already referred to.
Well, on your approach, do you need question 3 to be answered only after you've answered questions 1 or 2, or could you, in fact, deal with construction completely and then go on to the variant question?
I think it depends, my lord, whether you treat the whole process as a process of construction. I suppose you.
But you're saying I shouldn't,
yes.
and if you're saying
yes.
if you're saying that people are viewing improver questions 1 and 2 as factual questions rather than construction questions, if that is the right approach,
Yes, I think you're.
do you need a nevertheless
right.
at all? Can't you look at it first, saying, well, this particular patent, unusually, you'd say, standing Article 2, is excluding variants, therefore I don't need to look at the variants at all.
If it was clear that the patent excluded variants...
Yeah, but your test is, of course, that,
yes,
that
yes.
that must be very clear.
Then I suppose it might be possible to avoid having to look at questions 1 and 2, because if there's a specific disclaimer that clearly covers the alleged infringement, then there would be no point in asking questions 1 and 2.
It's the oddity of having a nevertheless after these factual
yes.
questions.
Yes, I mean, there is some, and it's put either way in Capnick, I think, or put either way in Improver, and it sort of reverses the burden, I think, as Mr. Justice Laddie suggested in Merck and Generics. But we say, whatever these old cases say, the introduction of Article 2 means there is a presumption that equivalents are to be taken into account and are covered unless there is a clear reason not to. And that doesn't arise in this case. And there's no reason to be strict here for the reasons we've given. No plausible reason why the patentee would want his claim to be deemed to exclude other salts, because it would make his monopoly for practical purposes worthless in the present case. Now, my Lord Mance raised the Angora cat, and it's an attractive analogy, and it may be of particular effect in places like Germany, where issues of infringement are dealt with in a separate court to the validity court. And so it could be possible to argue for different constructions on different occasions, i.e. a narrow construction for validity and a wide construction for infringement. But of course the answer to it is to allow the defendant to challenge validity at the same time as having infringement dealt with, as happens in almost all English cases, but as activists have not and have chosen not to do here. Therefore, the inference must be there is no squeeze, there is no validity problem which these claims would run into if you were to allow them to cover the activist products. And indeed, this is confirmed by Teva having withdrawn their opposition to the patent in the EPO and therefore accepting that it's valid. And of course, the Angora cat principle can apply equally to defendants, because a defendant could try to argue for a broad construction in the EPO opposition to make the target bigger, and then a narrow construction in infringement proceedings later. And so it's something that one has to be aware of, but it's not a principle that only benefits the patentee. It works both ways. It doesn't apply here because there is no validity challenge, and we say that the judge was wrong to consider that validity aspects should play any part in this assessment at all. So, my lords, finally, I think on this topic, I just need to go to the judgment itself, because my learned friend took you through the paragraphs of Mr. Justice Arnold's decision on question 3, and I didn't look at that in opening, and I should just make a couple of comments if I may.
Yep.
I haven't done it in relation to question 2 because Lord Justice Floyd quoted a paragraph 128, yes. And I think I dealt with all those points then.
Yes.
As far as question 3 is concerned, I think you'll anticipate my answers. Paragraph 131, we're in tab F.
Right. Yes.
This is the point where we say, well, the judge has already asked and answered the question in the first breath, because he refers to pemetrexid disodium as being a specific known chemical compound.
Yep.
He's already construed it, and effectively Lilly has lost on equivalence because he's construed equivalence out of it altogether. Paragraph 2, he refers to the specification, but our point is that there is nothing about giving up different salt forms.
You mentioned this at the very beginning of your submissions this morning.
My lord, yes, I did.
Yep.
They're not in the spec. There is spec in relation to the one form that was permitted to be put into humans, as you might expect, yes, for the tests that were done. 3, I think I've addressed. This is the difference between the terms for folate and B12. The point is there were different versions on the market of B12 and folate, and so those were specified.
Yes.
It's not a safe principle of construction, it's perilous. It wasn't relied on in Capnick. 134, this is the point on, we respond with the, why would you give up the salts when they're equivalent as far as regulatory law is concerned? Anyway, the tests are routine for the reasons I've given. 135, if this is the case, it's always the case, and in any case you should exclude equivalence because it might be said that there are outside claims which make them invalid. 6, I think I've dealt with what are the boundaries of the claims. We say, had the claim said pharmaceutically acceptable salts, there could have been no objection to that in terms of sufficiency, and so there's no reason to exclude or reject Lilly's construction for that reason. 7.
Sorry, what was the phrase you said? Had it said what?
Salts, as it said,
Pharmaceutically acceptable salts.
Yes,
in other words, it's claiming the ones that are pharmaceutically acceptable that work. We see wording of very similar nature in Claim 3, or Claim 2 for the folate, and no objection from a sufficiency basis is taken to that sort of wording, and we see it, so my lord, we say that it just doesn't work, and in any event, the judge should just have looked at the variants that were before him. Prosecution history I'm going to come to. 138, the judge was wrong to start to try to take into account issues of validity when they weren't before him, and deliberately so. And my lord, finally, in terms of...
Eighthly, is inconsistent with your submission that salts would be enough, isn't it?
Well, my lord, the added matter argument, I accept, of course, that there is no disclosure of that wording in the specification.
Yeah.
And so Lilly, having made the application, couldn't have used that wording for pemetrexed salt in the claim. But that's I'm going to come on to why added matter doesn't touch upon equivalence at all.
Okay.
In a moment in prosecution history. And for insufficiency, we say, well, you are entitled to do routine tests, find out the ones that work and don't work. And
that comes back to your argument earlier.
Indeed. And so finally, we have 148, where again he comes back to added matter, and we say the judge muddles the concepts of the scope of the claim and what the claims disclosed. And importantly, as I'll come on to show you, the claim to pemetrexed disodium was always there. It was there from the outset. It was in the original application, and it remained there. And so the suggestion that the meaning of that claim can have changed by virtue of what was done to other claims, we say simply doesn't run as a matter of ordinary laws of construction. And I'll show you that in the file in a moment. And finally, well, we come back to 149, where effectively the judge says, well, I'm construing it as literal, referring only to disodium, and I'm not allowing Lilly to broaden it beyond that, because the conventional wording is pemetrexed disodium means pemetrexed disodium.
Yes, we
say he's making...
We've been over this ground, Mr.
My lord, yes, I'm sorry. I just thought I'd better answer all of those points. So, my lord, in summary, if Actavis are right, we say infringement by equivalence is truly dead in the chemical arts.
Yeah,
and
we
it would
do
be
have
quite
that
wrong,
point.
my lord, yes. So prosecution history, if I may, and as briefly as possible, we have two themes to our submissions. Firstly, we say you don't need to look at all, but secondly, we say even if you do look at it, it's of no assistance in this case and no relevance to the scope of the claims in this jurisdiction or in any jurisdiction. My lord, perhaps I'll take that point first, because it's simpler and deals with matters in one go. So the first proposition is that the distinction between scope of the claim and disclosure of a claim or a specification is well established in the law of both the United Kingdom and the EPO. Yeah. And perhaps the best exposition of that is in the extract of Terrell that Actavis have referred to, and that's in bundle AV4 tab 1.
Right. Thank you.
And it's page MS4269. And perhaps your lordship would just read paragraph 1537, which sets it out.
Yeah. Yeah.
And this is because of the difference between disclosure, which is a formal requirement,
Yes.
clear and unambiguous disclosure looking at the words, and scope, which of course goes much further for the reasons we've discussed. And this is absolutely standard in the EPO as well as the UK. So if you have a patent in the EPO and you refer to butter in your specification, you can't write margarine in your claims because the EPO will say, well, you haven't disclosed margarine, you've only disclosed butter, even though plainly margarine and butter could be said to be equivalents. And the EPO are quite clear about that, and we've given the references to the case law book in the EPO where they explain that equivalents are not relevant for the issue of added matter because of the difference between disclosure and scope. So any restriction or concession because of a lack of disclosure does not mean that the patentee has agreed to restrict the scope of his or her claim because of the differences in those two concepts. My learned friend took you to the prosecution history, and I'd like to make this submission good by reference to the facts of this case.
Yes.
And the overall submission is there's nothing being made by way of statements by Lilly that could be said to exclude equivalents to pemetrexed disodium under any of the relevant laws.
Yes.
And these are in Appendix 2, tab 7. This is the application as filed, and if your lordships turn on to page MS 939,
Right.
you'll see the original claim set applied for, and if your lordships look at paragraph 11, you'll see a claim to an antifolate, the use of a methylmalonic acid lowering agent in combination with an antifolate, and then in claim 15, the use of any one of claims 11 to 14 wherein the antifolate is a limpter. So, my lords, the basic point is that there was always a claim that's the same as claim 1 now, that is to say, a limpter plus B12 to reduce toxicity, and nothing that can have occurred during the prosecution process can change the meaning of that claim or the fact that that claim has equivalence to it when looking at the scope for the purposes of infringement.
Yes.
And, my lord, that's made good by what's said in the prosecution file as we go forward. So if we take tab 8, which is the first...
Yes. First letter.
First letter.
Yep.
And the objection at the bottom of the page, clarity and lack of disclosure, and the objection went to the fact that the claims were expressed in functional terms, e.g. antifolate or methylmalonic acid lowering agent or FBP binding agent. And it said that this is unclear. If we turn over the page, you'll see the novelty and inventive step objections went only to the fact that the claims referred to antifolates, and it was said there was relevant prior art which referred to other antifolates. Yeah. So we see reference to 5-fluorosyl and methotrexate in those paragraphs. That shows you what the scope of the objection was at that time. So Lilly came back in tab 9, and they submitted revised claims which omitted these general functional terms and at the same time dealt with the novelty objections because the claims were now limited and antifolates generally were no longer claimed. And of course, because Actavis are not selling a different antifolate, this limitation or the fact that these claims are no longer there isn't relevant. It might be were Actavis to be selling lomotrexol and vitamin B12, we would be having a different argument, but it's
so 11 and 14 are varied.
Sorry, my lord.
11 and 14 are varied, are they?
11 and 14. Claims 11 and 14 stay in the same form. They haven't changed all the way through. They've been combined in the ultimate claim 1 into one claim, but we say that there's always been a claim to a limpter and B12, and therefore none of this is relevant at all to the scope of the claim that is now in existence.
Thank you.
In tab 9, there's nothing in the wording of the letter to show that Lilly was reducing the scope of the claims that were already there. that is to say 11 and 15. It is said that, the deletion of the antifolate claims is without prejudice to the right to apply for a divisional, but that, we submit, would be understood by the skilled person as a statement about the claims that are no longer pursued, that is to say the antifolates, and of course, in fact, no divisional was in fact applied for. So if this is relevant at all, the skilled person would see that there was no other divisional and would not think the fact that Lilly had referred to this in the letter was relevant at all to the claims that are now in issue, that is to say, pemetrexed disodium. Then the claims are submitted referring to pemetrexed, and the examiner comes back in tab 10 and said that there was no basis for this on the grounds of added matter, and we see heading amendments, Article 1232.
We looked at that.
And he says there was no disclosure of the word pemetrexed in the specification, and this could mean something different.
Yes,
and we adopt my Lord Justice Floyd's observations in paragraph 27 in the Court of Appeal, where he said it was at best uncertain as to what the term pemetrexed was intended to refer to. My learned friend this morning suggested, it's clear that pemetrexed here referred to the diacid. And Lord Justice Floyd says it's not clear that it does refer to the diacid at all.
Right.
And so there can be no relevant finding that this is a rejection of any claim which is said to be equivalent to diacid, even if Actavis's product was just a diacid, which of course it's not for the reasons that I've explained. And then, my Lord, at the bottom of page 18, we see a heading, clarity and lack of disclosure. And then if you turn over, your Lordships will see reference to the term pharmaceutical derivative in various claims.
Sorry,
now, my
what
Lords,
page are we on?
I'm on page 959 at the bottom.
Thank you.
And then 960 at the top.
Thank you. Yes, I see.
And, my Lords, just to be careful here, because my learned friend tried to take these all together, but in fact the objections under the heading clarity and lack of disclosure are only to elements of the vitamin B12 aspect, because your Lordship will see at the top of page 960, this is referring, it's the phrase pharmaceutical derivative which is objected to, and that's only relevant to the B12
I see.
In the claim. So there was no objection to the pemetrexed simpliciter claim other than under Article 1232.
I see. Yes.
Now, yes, and the comment is that it would be an undue burden to randomly screen undefined compounds for their claimed activity of an anti-toxic effect. My Lord, that's all to do with the B12, and of course that's central to the invention, and the examiner was making a different point to the point that's now being made about the salts. My Lord, finally, tab 11, we say there's no relevant limitation by Lilly in the letter that responded. Lilly were very careful to write the letter in the terms they did. It says the claims have been amended to refer to the preferred embodiment, the use of pemetrexed disodium olympta as manufactured by Eli Lilly and Company as the antifolate drug. It's a pure statement of fact. There's no representation that there is a limitation. There's no representation that there's a less of a scope by reference to the amendment that's been made. My learned friend, Mr. Alexander, used the word limit a number of times yesterday, but it's not used anywhere by Lilly. So, my Lords, it's clear from this, we submit, that there was no relevant limitation by Lilly in scope or otherwise. And indeed, if you take Actavis' submission literally, then you would understand that Lilly had sought to limit the scope of the claim to only pemetrexed made by Eli Lilly and Company, because that's what they say in the same sentence, and that's obviously absurd. They weren't limiting themselves in that way or at all.
Yes,
and, my Lord, we say the effect of this is that there's no conclusion can be made that any relevant limitation was made under the laws of any of the relevant jurisdictions. The claims mean exactly what they did in the application as filed. There have always been equivalents to pemetrexed disodium within the scope of that claim and the claim that's now in existence. Nothing to suggest that Lilly have given up on any other cations, no conscious limitation, no explicit, unequivocal, clear, precise, conclusive, undoubted, and unambiguous limitation as required under Spanish law. And the fact that Lilly did give up claims to antifolates, other types of claims, is really irrelevant to the issue that's currently before the court on the form of the salt for the pemetrexed. So we say the prosecution history just doesn't bite at all on the facts of this case. And my lords, Actavis' submission is to the effect you can never have equivalence after amendment. But as almost all claim sets are amended during prosecution, and indeed I think Lord Justice Jacob observed that if a patent attorney wasn't trying to seek the broadest claims he or she could, he wouldn't be doing his job properly. So this is a fact of life that narrowing does take place during prosecution. If Actavis is right, you could never have equivalence, and Article 2 would be meaningless given the prosecution process. And that would be very unfair on the patentee, quite extreme, and is not the position that's taken in any of the jurisdictions that are before the court. Finally, my lord, on the file itself, we would just like to remind you of the German position. The paragraph 1 of the joint memo, as I said, we don't think we need to turn it up now, it's bundle 5, tab 9, page 4530, says that they don't look at the prosecution history. It's right that the Bundesgerichtshof did look at it a little bit, because the Court of Appeal did in this case, but if your lordships read the passages at paragraphs 64 to 72 of page MS 714, tab Q, particularly paragraphs 68 and 72, you'll see that the Bundesgerichtshof agree that Lilly did not limit their claims in the way now suggested by Actavis, and we say that is helpful and
thank you.
Our submissions. My lords, I have one more topic left, which is whether you should look at prosecution history at all, which will take me 10 minutes or so.
Right, well, perhaps we should adjourn until after short adjournment, because Mr. Alexander is coming back.
Yes, my lord.
His appeal.
We did anticipate that time might be a bit pressed this morning, so we have produced a note, in particular in relation to the foreign law issues, which may be helpful for your lordships to have, and my own friend to have to look at over lunch, which will cut time down.
Well, certainly, I mean, your time has been intervened by about half an hour, so you've got half an hour after. Well, no, you've had about quite worked out, but you're probably up against it. On the other hand, if you're going to give us written stuff, then either Mr. Alexander is going to reply to it on the hoof, or he's going to have a chance to reply to it in writing.
Yes, well, it's only what I was going to say, so in some senses he's having it earlier.
Oh, yes.
But we thought if time was a problem, if I hadn't...
Okay, well, hand it in now and we'll see where we go.
Oh, yes.
You give it to us. We'll rise now. You give it to us outside. So we'll resume again at 2 o'clock. Court's now adjourned.